afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge, where we discuss all things edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, the cutting edge. Those of you joining us live this afternoon are receiving early bird access to this episode. If you have a question, please type it into the comments section below and we will be sure to address it, because as a live participant, you have the opportunity to ask questions and interact with our speaker. If you happen to be unable to join us live, however, episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today, we have one of my favorite KTI and KLF people, Mindy Bish, with us to speak about what's new in the Edge tractor trailer section. If you have a tractor trailer case you believe meets the criteria for becoming a referring attorney with the Keenan Law Firm, I highly encourage you to submit it simply for the opportunity to work with Mindy. When Mindy gives advice, you don't have to second guess it because you know it's the same advice Papa Don would give. She's so incredibly dedicated to making sure you succeed when you work with her that not a text goes unanswered or a call unreturned. Much like Papa Don, I wonder when she sleeps. I'm thrilled to have Mindy on with me today. So Mindy, tell us what's new and exciting in the Tractor Trailer Edge section.
All righty. Thank you, Jenna. That was quite nice. Thank you. All right. As most of you know, I am the Keenan Law Firm partner that handles the tractor trailer cases. I also handle the premise cases from the referring attorneys. Today, I want to talk about an issue that I see a lot on the tractor trailer listserv, and that is this issue of state after state that is basically passing laws that favor tractor trailer companies and eliminate your ability to allege negligent entrustment or get into the hiring, training, and supervision. And that's one of the key issues that the tractor trailer groups have been addressing probably for the last 6 months to a year. What do we do when that's our state law? And so what I want to do is to go through some suggestions as to how we are handling it under Mr. Keenan's direction in the tractor trailer group. Number one, first and foremost, hopefully all of you are doing the research to find out what the law regarding punitive damages is in your state. Can you get punitive damages by showing gross negligence? Or is it an elevated showing? I mean, is it wanton? What is it? What I find happens a lot of times from all of us is we think to ourselves, oh, I've handled 1 million tractor trailer cases. I know my state's law. I don't need to look. And then you go and you look and you find out that something has changed since you looked at it 20 years ago or 10 years ago. So first and foremost, if you're handling tractor trailer cases and you're in a state in which they're either leaning towards or they've already gotten there to try to tie your hands on that, my recommendation to you is, and it's what we all do, is step number one is a memo on what is the punitive damage law in your state. Gross negligence, wanton, what do the cases say that you need to have in order to get it there? Now, when I say that, what I mean is that our attorneys in the referring attorney group do that research at the very commencement of the case, meaning when the case walks in the door, not when the case is already filed, not 6 months down the road when you're facing trial and they're going to stipulate or agree to course and scope. By that time, it's too late. So one of the key things we do is this notion of anticipating these issues and addressing them from the get-go. So step number one is to do the memo on punitive damages. Do the research in these cases to try to figure out what you're going to need to show. Now, there are some states that are still lucky enough that negligent entrustment stands as a separate cause of action. And so even then, you need to do the research on what do I need to show? What is the evidence that I need to get? Most of us, especially at the Keenan Law Firm, we are grounded to the law. It's understanding the law when you start, because that'll dictate everything else that you do. So to give you an example, I'm going to share my screen for a minute and show you, let me just back up. I'm going to show you a case that was with the tractor trailer group out of Wisconsin, where the issue was this negligent entrustment of getting punitive damages into place in order to be able to make sure that our evidence is admissible. And so one of these was done in order to lay out for a judge, by the way, to show a judge rather than tell a judge what the evidence would show. So let me share the screen and give you some idea as to what it was we were able to develop. Moving papers, and that was actually used during the argument portion of the hearing. And what it did is that Transit Express had a written procedure policy that said for your first violation, you got a warning. Your second violation, you got a written warning. Third violation, suspension without pay. And fourth violation was termination. And when we went and we looked at the records for this particular driver, this is what we found. 821 of 2007, violation number 1 for using a cell phone while driving and failure to put away the seat belts after the shift. Violation number 2 was a written and verbal warning for speeding and unsafe driving and improper language.
Mindy, I'm not able to see your screen share. Hey, Ryan, can you check and see?
Well, let me share it then. Hold on. I may need to share it to the other screen. So let me screen share to my main screen. Are you able to see it now, Jenna?
There we go. Awesome. I was wondering if it was just me, but I checked with Young G because she's watching and she was like, I can't see it. So
let me just back up, and I apologize. It's how PowerPoint works when you have two screens attached.
It's all good. Thank you.
All right. So we told the judge what their policies and procedures showed. And then we showed what this guy did. So you had 82107, you had violation number 1 for using a cell phone while driving. He was given a verbal and written warning. You had violation number 2, which was speeding and unsafe driving, and improper language, which he was given a verbal and written warning. He rear-ended a vehicle while driving. He was inattentively and with inappropriate speed as approaching an intersection. Then violation number 3 in 2009, speeding in a neighborhood where children play. 2010, violation number 4, he was suspended for using a cell phone while driving. Violation number 5 was a verbal warning with a failure to empty the trash after a shift. Violation number 6 was a verbal warning for using passenger fares for personal use. In other words, stealing. Violation number 7 was a second suspension for using a cell phone and speeding and unsafe driving in neighborhoods and intersections. Violation number 8 was a written warning for using passenger fare for personal use, otherwise known as stealing. Number 9 was a third suspension for using a cell phone while driving and not wearing a seatbelt. Number 10 was a written warning for speeding and unsafe driving in 12. So from 2007 to 2012, we're now at 10 different violations. The 11th was a forced suspension for an unauthorized stop to handle a personal matter. Number 12 was a written warning for using passenger fares for personal use. In other words, that's the third time he was caught stealing. 13th, a written warning for being absent from work for a total of 14 days. Violation number 14 for being absent from work for a total of 9 days. Violation number 15, and you're talking about 15 violations in a 6-year period of time using passenger fares for personal use. That's the 4th theft. Number 16, a written warning for being absent for work for a total of 7 days. That's the 3rd time he basically was a no-show at work. And then the 16th over here was then we had the date of our crash for 2016. Now, we could do this because we were preparing from the beginning for in some states, you have to make a motion for punitive damages after you have filed the case. For example, I believe you do that in Florida. In some states, you put the punitive damage allegation in your complaint. But all of this was geared towards being able to support a punitive damage claim, which is one of the ways to avoid the state laws that take away from you negligent entrustment. Why? Because you get punitive damages in the complaint, they can no longer admit the conduct. You precluded them from using that defense technique. And so one of the things that's the cutting edge is looking, and it really shouldn't be, but for some of us it is the notion of looking for punitive damages in every case. You have to understand the law because you have to know what it is that you're going to go get. So in this case, we were able to show all of these different violations as part of the motion for punitive damages. Now, let me stop my screen share just for a minute, and so we can talk about this. Now, don't wait. You know, so many of us now think that somehow the edge is this thing where we surprise the defense, where we hide things from the defense, where we don't give them the time. There's no reason to do that. They can't escape the law and they can't escape the facts. What you don't want to be is in a position of walking into a courtroom where the defense attorney says, we're 60 days away from trial, and this is the first I'm hearing of a punitive damage claim, and now I need a trial continuance if you're going to grant it. And all of that stuff plays against us because it also lets the judge know that we're being tricky, that we're withholding, that we're not being honest about where we're headed in a case. And so one of the key points, and then it's another, it's what we are working on in this tractor trailer group is getting these things out early and often, using the information that you have, letting the defense know where you're going to go so that they can't claim surprise. oh my goodness, I'm surprised. And so mostly it is what Mr. Keenan would call essentially, I believe, although I was in the Air Force, he was a Marine, but I believe this is what we would call the Marine, the Marine way of doing this. In other words, making sure that we are out in front and prepared. So that's one of the things that I will be working on. Hold on for a minute. Hold on. Sorry, they were starting to vacuum, so I needed to tell them no vacuuming until I'm done. So it is this notion that we are our own worst enemies because we don't properly prepare our case. We aren't looking for it. So the number one thing is know the law. Do your research on punitive damages, do a memo. I don't care whether you think you know what it is. Even if you don't think, there are some states I'm aware, Jenna's in one of them in Washington, where you just can't get punitive damages. I get that, but that is not, thank God, the norm, across the United States. So you need to, number one, work really hard on making sure you preserve punitive damages, gross negligence, whatever it is, don't overlook it. So that's the first thing that I'd like to address. Now, I have different topics that I think are cutting edge. So if you have questions, make sure you type them in as we go along so that I can answer them in the context of where I am at. Jenna, did I have any questions on that?
Sorry, I had a hard time unmuting myself there. So far, no, but I will definitely jump in if we do have it.
All right. Well, I just wanted to make sure because I'm going to be going on to the next topic, which is the cutting edge stuff that we're working on. The other thing that happens that we're spending more and more time is I get a lot of attorneys who call me. Part of the tractor trailer group, there is a bottom line as to how much your case is worth. And I cannot tell you how many attorneys call me and go, well, I just don't think my case is worth 7 figures. And they tell me the story of what happened here. And all I'm thinking is, it's worth way more than what you think it is. And what we are finding in the tractor trailer group is not paying enough attention to the damages. We also get so locked in to the notion of punitive what we can get in, liability stuff, that we don't spend the time with our clients. Really, that goes to, all the things Mr. Keenan has talked about from the very beginning about spending time with our clients and truly understanding the limitation of what those injuries have cost. I just spent some time on the phone with one of the referring attorneys yesterday talking damages. So we spend a lot of time working up the damages. And, Jenna was in the tractor trailer group at one time, and I'm sure she can attest how many times we don't understand what the damages are or what caused them. Mr. Keenan has, during the workshops, he has, legs and arms, the kinds of things you would use in trial. And a lot of times he'll hand them to somebody and say, show me on this how this injury happened. What is the cause of the injury? And so many times we get, I don't really know, or I don't really understand. And so, one of the things that, we talk about is you have to understand your client's damages almost better than they do, better than the doctors. It's not that you're going to use it at trial, but you have to know when somebody is blowing smoke, so, in our tractor trailer group, we spend a lot of time on the damages. Now, talking about damages, let me share my screen again, and I will share the right monitor for them and pull this up. One of the things that we're doing is how do you take extensive damages and be able to lay them out in a way that everyone will understand. So this is back to that case. And so one of the issues here was that Jennifer had headaches before the crash, and then she had a brain injury. So she had headaches afterwards. And so what we did is we put out, basically a timeline. So in 11/5/99, she had a headache. No, the medical records didn't show any other headaches till 4/14/03. Then on 2/28/08 was the next time she was treated for a headache. And then on July 15th of 2008 was the next time she was treated for a headache. Then not again until 2011. And then in 2012, 2014, one visit, 2015, one visit, July 2nd, 2015, a visit. So she had 9 visits for headaches over a 16-year period of time. Then the crash occurs. And now we look at the medical care following the crash. Crash occurs, neck, head, shoulder, and hip pain, nausea. Then you had basically 2 days later, sees a doctor for head, ribs, shoulder, hip, blurry vision, ear ringing, headaches on still October. And we run through and are able to show all of the different complaints of injury that the client makes before the crash occurs and then after the crash occurs. Now, laying out this kind of information, by the way, is something that we do before a lawsuit is even filed. And why is that? Because what we do is we give this to the defense. This is not a secret. And I want to emphasize that what happens so much of the time is we treat this information like it's a secret. And then we put this together and we have this and we go in to trial and the defense looks at you and says, Your Honor, this is unfair surprise. I've never seen this before. And when we do that, what we do is we give the defense, once again, a foot in the door. So once you put together your PowerPoint or whatever you're going to use of regarding all of these different complaints of pain, it's something you use with every one of their experts. It's something your experts use and rely upon. You can see the headaches continuing across the bottom, word finding, anxiety. And what you do is you use this often in every way that you can. So as you can see, our motto in the tractor trailer group is we are not waiting until the end, right before trial, to prepare these things. We are doing the research on all of this stuff long before a lawsuit is even filed, so that we can be sure it's used throughout the entire discovery process, so that we can be sure that the defense has been seeing this for years. So that when trial rolls around, once again, you are not left in a position of having to say, well, I created it. I gave it to them as soon as it was done. I just didn't have it done until a week ago. What we found is when you do that, you've shot yourself in the foot. The reason, what you get a lot of times when the lawyers first start with the tractor trailer group is this notion of, I'll never get it in, my judge will never do it. Well, of course he won't. If the first time anybody has seen it is the week before trial, it's easier just to say no than to go through it. But if you can show that you've used it consistently throughout your entire discovery process for 2 years, the judge is not going to tell you no, because it's been out there. The defense has known it. His experts have seen it, just like everything else that we do. And so, in addition to doing the research, being prepared early on, reviewing all the medical records, lining it out so that you understand what all the client complaints are, what all the injury stuff is, doing it early from the very beginning, and then using it, planning for its admissibility at the time of trial is really where we're moving. I remember when I first started with the Edge, a lot of it, the cases were, 2 weeks before trial. So I didn't have any choice but to kind of do an opening that had a stat in it that nobody had ever heard of before, but now I know better. I know that I don't get anything without the hard work. You should have a memo on statistics in your jurisdiction. All of these things should be old hat to the defense in that they've known forever that it's going to come in. So I guess that's kind of the long way of saying that what the tractor trailer group really works on is changing our old bad habits. The bad habits that say, the bad habit that says, I'll do the majority of my preparation a week before trial and hope I get it all in. Or all of a sudden I'm faced with them going to the judge saying they're admitting course and scope, and now I've lost all my hiring, training, and supervision because I didn't plan for it and already have it addressed long before. So I become my own worst enemy. I don't develop my damages. I don't call the client enough. I don't find out from the client how they're feeling. I don't learn from before and after witnesses how it is affecting their life. I allow the defense to dictate it, or I wait too long to acquire a lot of that evidence. So I need to have it. One of the cases we have in Las Vegas with the tractor trailer group, they've attended a lot of the anti-reptile, although we're not a reptile anymore, we're Edge, seminars, and they file these preventive motions as to what questions you can ask in a deposition. Well, if you don't already know all your own facts, if you haven't accumulated it long before, how do you make a viable argument to the court when faced with these ludicrous motions? So, one of the things that we see a lot of is people who say, I've been doing tractor trailer cases for 40 years, and they do them the same way. And they don't go back and they don't look. So those are the more pressing issues. It's, knowing what a TBI is, understanding the injuries better, understanding why it happened. Why did it happen? So that you can go after it. Jenna, do I have any questions yet? No?
Not from the live audience, but I can ask some that I've been kind of stewing over here about. Would you like that?
Go ahead.
All right. Let's see. So one of the big things I notice as well, even within our own firm, is that aspect of understanding the damages, right? We say, okay, so there's a broken arm or there's a brain injury. And we're like, okay, I understand that from a conceptual point, but do we really understand, number one, how it happened, but number two, how it really affects their lives? Can you share with us how we learn that information? Who should we talk to? When should we talk to them? And how do we go about doing that investigation for our clients?
Sure. So part of what we do is we have essentially a list that tells us when we go, where we go, and what we do. Damages, you're talking about the people who know your client the best, who have observed employers, supervisors. Most of you know the story of the dry cleaner. You need to talk to these other people to get their observations. You need to develop a relationship with your client early on so that you become a confidant. I mean, they're not going to just trust you because you met them 5 minutes before trial. They're going to trust you because you've been spending time with them for the last few years. So you want to make sure that you understand it. Mr. Keenan will tell you, you go to their house, you spend time with them, you see it with your own eyes. That question, Jenna, and I'll come back to make sure that I've answered it fully for you. There was a question on the listservs this last week, and this whole notion about, who do we call? You're looking for people who know your client, who've seen your client, who are not related, that don't have anything to gain. Because Bubba already thinks, if you call the wife, of course she's going to say that. What else would she say? Or the mother, or the father, or the sister, or the brother. So you're looking for those outside people and those stories. So the damages are something that you should have a relationship enough with your client to know what those are, so that you can compare them to the medical records and know whether something's missing.
That's a good point. Because sometimes you have a client who thinks one thing about their injuries and their damages, but maybe it's not quite that. And it might be something different. Or, it even could be psychological, which is still a damage, right? That's why is this happening? And if we just present it to a jury without the why is it happening and that causal connection, the floor falls out underneath your case. And you don't want to be surprised by that.
Or worse yet, you wait to review the medical records till a week before trial. And now you understand 3 weeks 3 weeks before trial that the injuries you thought your client had don't appear in any medical records for years, versus reviewing the medical records and understanding and building the notion of what they are as we go along, so that you can immediately notice an inconsistency rather than just being stuck with it.
How do we get better at reviewing medical records and understanding the medicine? Because sometimes that can be really overwhelming and honestly kind of boring. So how do we get better at that?
Well, Mr. Keenan always recommends coloring books. So if you go onto Amazon for any injury, they have them for everything: head, neck, brain, foot, whatever they are. You can find an anatomy book on Amazon that's a coloring book. And so, when you say that it can be boring or whatever, but it's really not when you're coloring in the pathways. So I have probably 5 or 6 coloring books that I got from Amazon that help me teach the anatomy and understanding where everything is at. Number 2, it's the experts you hire. Mr. Keenan will tell you that the experts you hire, they want to know that you know the medicine as well as they do. And once you convince them that you have done your homework, then you can go back and you can ask questions. Go, make an appointment, pay the money, sit in their office, bring in your trial exhibits, your arms, your legs, whatever those are, and say, can you show me on this so that I make sure I understand how this injury occurred and what it is and what you would expect to see from it? Because maybe those doctors also would say, well, did you ask your client about this? And you never even thought of that would be something that you would need to understand.
A lot of people use either a paralegal or even a third party person to do a medical records review and go through and summarize things. Is that okay? Or do we need to be reading stuff ourselves? Or is there a combo we can use there? Just, someone says, I don't have time. I get that a lot from colleagues who I tell you need to do these things. And I say, but I don't have time.
Well, I guess it would be based on what your individual needs are. There are some people who can hire out good companies that go through the medical records and put together, graphs or timelines or however they do it that summarize the medical records. And for those people, and they have a good enough relationship, they can kind of review it later on to make sure that it's accurate, but that works for them. For me, I tend to take the notebooks and go through it all for me, because once I go through it all and I do all this, for me, I know it cold. That's how I learn it. I know everything cold. And if I have you do, it's something about, be surprised, right? It's what we tell you about juries. It's something about reading it, writing it, looking at it, that then makes it something that I own. So I think that that's really a personal choice, as long as you're thorough. You can't turn it over to somebody and say, okay, they did it, I don't need to do anything at all.
Okay. Yeah, I tend to be similar. I need to look at it and really understand it. Otherwise I miss things, and I miss it. And then I don't want to do it. And then I force myself to do it. And I realize, oh, thank goodness you did it, because you would have missed this otherwise. And actually, I wanted to tie this back into your first topic about the negligent entrustment topic, because it's directly related to something that I experienced recently here in Washington. We don't have punitive damages, but we do have a really robust case law about deterrence. And so even though we can't necessarily punish the defendant with a verdict because of what they did in this case or anything, you can use the deterrent argument to introduce a lot of contextual evidence, like what you showed, Mindy. You may not get it all in, but you can use it as ammo for the court. And, we do have, I discovered, and this is why I mentioned after doing your own research, people have been telling us for so long, there's no corporate negligence in Washington. It's gone. It's dead. And I found technically it's in a medical malpractice context, but I think it can be used in other contexts, and I'm going to use it because I went in and I read every single one of the 42 cases in Washington that have to do with this, and it's there. It's there. And it's like, you don't rely on what defense tells you about the law. Don't rely even on what your fellow attorneys, tell you about the law. And it's not that they don't know. It's that they've taken for granted these just widespread things, these concepts, and you got to get in there and do the work. And I'm really glad that Mindy is sharing that with us, because getting in there, reading the cases with your own eyes, sometimes people misunderstand a holding of a case, and then it just spreads like wildfire and nobody wants to fight about it. And they're like, well, I can't bring that claim because I'm just not going to ruffle anyone's feathers. So
well, I can tell you that almost every referring attorney starts with we can't do this in our state. Mm-hmm. And they leave with, oh my goodness, holy, we can, and so when we go back to do the research and we really dig, because I can tell you with Mr. Keenan, and I'm sure Jenna can agree, he never accepts we can't do this in my state. Never, ever. And even on the medicine, what I can tell you is he always finds in the medical records the thing that the RAs missed, the referring attorneys missed every single time. He'll bring up, well, what about this? And they go, what? And so, it's that thorough understanding of what's there. And really it's doing the homework. And if I can summarize it, it's not looking at tractor trailer cases like I've done 100. It's just another tractor trailer case. It's looking at every single one with a set of fresh eyes, determining where are my pitfalls and planning from them for the beginning.
Mm-hmm. And figuring out how you're going to present your case to get in what you want to get in. Because there's not just one way to get things in. I remember the very first edge case I tried, and the court shut us down. I mean, a lot like the Boston case where Don wasn't allowed to say any words. I was very similarly not allowed to say any words. And I was just like, oh my gosh, what do I do? And some fellow edge attorneys were like, you got to keep going. Get a thesaurus and find other words that work. And similarly, get a case and find out what the holding is, find out a similar legal theory or concept and fit it in there, use analogies, use things to educate the court, because remember, the court oftentimes doesn't have a background in the area of law that you're putting before them. Or maybe they've had a few cases, but maybe they haven't been tried the way you're trying it. So this is all about educating. And another good point Mindy made is sharing stuff early on, because when you're educating the court and you're educating defense and everybody is kind of learning about this new way of doing things, or, not really new, but just this more thorough way of doing it, then you're in a better place when you get to trial. And maybe you don't even get to trial because they've learned from you.
And you've got to eliminate the, I can't do this in my case. And I see this more in tractor trailer cases almost than anywhere else, because everyone thinks that they so know what to do. We'll hear things like they are admitting course and scope. They're not going to answer any questions on training. Ask them anyways.
Mm-hmm.
So it's a lot of pushing people to ask them anyways, and those are, they may not sound like cutting edge, but given the fact that people come in the door not doing them in our groups, this is opening an entirely new area that they have not experienced before.
Mm-hmm. And be confident and be persistent too. I spent 4 hours in a deposition last week, and at least half, if not more, was spent with defense counsel yelling at me about the questions that I was asking being confidential. And just like Mindy said, I asked them anyways. I was like, I want it on the record that I asked and you told your client not to answer. And then I'm going to go back and see what a focus group has to say about that. Because do they think that you should, whatever the law says, I don't care. Because what I really care about is how that's going to look to a jury. And if you think that you can get away with saying, well, we're not going to answer that question, this statute says we don't have to answer it. I don't know, maybe you can, and we'll see what a focus group says about it, but maybe you can't. And that way you've got it on the record that you've tried. And you can also use that for inroads with the court. If even if there's evidence that it can't come in your case in chief, maybe there's a way to use it as impeachment. If they decide to say, well, we've been doing the right thing. Well, here's this, deposition where you wouldn't even tell me what you've been doing. So really, have you been, that kind of stuff. Just got to be kind of creative about it.
Well, I mean, Stacy Cutting will tell the story. She has a case with the tractor trailer group, and she was getting ready to take a deposition, and Mr. Keenan was working with her on the questions to ask in the deposition. And in this particular case, Stacy was really worried about getting the answers of, I don't know. I don't know, and Mr. Keenan was able to say to her, embrace the I don't knows. Don't push it. I don't know is just fine. And later we were able to find out that I don't know pissed them off more than any answer they would possibly have. And so these are the insights, the things that we move you along for in tractor trailer.
Yep, absolutely. And the corporation's going to try to protect themselves as much as possible. And sometimes that's going to backfire. And you just want to know and be prepared about how, when to let it go and say, yeah, I'm, versus there are some questions you want to keep asking over and over again. And Mindy, you have this experience with one of your cases where you had to just calmly rephrase until you got an answer. But other questions that I don't know, or I'm not going to say, ooh, that's good. And it's something you want.
Yeah.
Especially on like the questions like, what did you learn from this? Or what are you going to do differently? We are not answering that. Okay. Don't even think about asking that question. We're not answering it. Okay. That's interesting.
Yeah. So it is about, understanding so much in tractor trailer. One of the things that I'll come back around to is that a lot of these major companies, they get into a crash, right? And the very first phone call that's made is to the attorney who's on the scene within 15 minutes of the crash occurring. And now you're in litigation of the case, and that attorney's telling you that all the investigation they did is attorney work product. So the answer is, do you really know what attorney work product is? So it's the idea of, well, that's all attorney work product. Well, okay, but I'm entitled to a list. It's being persistent enough. I'm entitled to a list of the evidence you have that you are now saying is protected under attorney work product. I'm not just going to agree that you know the law better than I do. And so I want a list. Now, what are you going to do with it? So, if you're taking a case against a major company, you have to anticipate that these things happen because they're already, here's the key. They're already anticipating the lawsuit. They've been working on it since 5 minutes after it happened. Have you been working on it since 5 minutes after it happened? Are you meeting them head on, planning for everything you think they're going to allege from the moment it walks in the door? Or are they pulling the strings and you're just following along? Mm-hmm. So, that is what we work on the most, because 90% of our cases, the defense attorney has already been hired 15 minutes after the crash occurred.
Mm-hmm. Yep. And you want to know every objection that they make and every argument they make like that. Is it really what the law says? Because they know the law darn well they do, but they will change it a little bit or expand it a little bit, hoping that you don't call them out on it.
Correct.
Don't want to let that happen. Just like Mindy said, don't let them be the puppeteer and you just be like, oh, okay, I won't ask about it. You need to get in there and maybe they're right. Okay, whatever. Then you found out that they're right, but you figure out a way to really make sure that you understand it and you know it so you don't miss something. And then that's on you if that messes up your client's case, right? If you believe something the defense said and that really wasn't true and you could have maybe gotten more information, could have maybe gotten more damages. So be real careful about that.
Well, and, going back to the theme, which I started off with, which is know the law and do your research. How many of us have worked on or have, pocket briefs or memos on what exactly constitutes attorney work product in whatever the state is that we're working, and have read the cases? How many of us know what is the effect if this attorney alleges attorney work product here? Is he forever barred in my state? When can it come in? Who can he give it to? Can I get it from that person if he gives it to a third party who is out there? And that all goes back into making sure, because I will tell you that Mr. Keenan knows the law on all of these different aspects better than the defense attorney long before those issues ever come up. And so, when we talk about cutting edge, really it's almost back to basics. It's being able to understand what the answers to those questions are. So if he says attorney work product, are you in a state where that means it ain't ever coming in? What effect does that have? Maybe that's okay with you. Maybe it's not. How much time have you spent looking at the law and analyzing this before you open your mouth or file your motion or do whatever? Or are you just knee-jerking doing what you've always done? Because if you're doing what you've always done, you're going to get what you've always gotten. And if you want, part of coming to the edge is for those of us who want to get something new, different, and better.
Exactly. And think about why you're doing something. Why am I looking for this piece of information? Is it because it's in my pattern interrogatories and requests for production, and that's just what I've always done? Is it because I learned it at some, CLE or something? Or is it because it's really designed to get what I want it to get? Right. And be conscientious about what you're asking for and why. I had a colleague reach out about a motion that was filed and she wanted help defending it. And I was like, well, have you thought about the fact maybe you don't want to fight this too much? Like maybe the outcome that the defense wants is good for you. Think about that, because maybe, so you really kind of want to be intentional. And that's one of the things I learned a lot from the Edge is be really intentional about what depositions you take, when you take them, why you take them, in what order, what evidence you're looking for, what battles you choose your battles, which ones do you take to the end of the line, and which ones are you like, my energy is better spent elsewhere, because defense's job is to just spin your wheels and make you crazy.
Well, and that's what we spend our time in the tractor trailer group doing, is planning out these cases from the beginning, making sure that we have all the law, making sure that we understand all the damages, finding out, did the defense attorney show up, 5 minutes after the crash? Who else showed up? Making sure that we get all of that information, is what we do. And, Jenna brings up a point. We've had cases where the defense files a motion to exclude what we know is actually the worst piece of evidence we could have. The jurors hate it. So how do we suck them? How do we do all of that? They do it. This is not rocket science, but it really is about, when you talk, does the judge believe that you are the master of the law in the courtroom? It's really, and if he or she does, then they will rely upon you more. And if he or she don't, then you're dead in the water. So are you prepared? Have you done the work? And not a week before trial, not when faced with motions, but way before you file, from the moment the case walks through your door.
Now, Mindy, if we want to submit a case to potentially be considered by the Keenan Law Firm for a referring attorney, how do we do that? What are the criteria? And I guess, where do we go to figure that out?
Well, you would send over just an email to me at mbish@keenanlawfirm.com. That's mbish@keenanlawfirm.com. And I can take a look at it. We have certain criteria as to value. It has to be, a 7-figure case. It has to have insurance that would cover that kind of a judgment. And it can be, a car crash case with a company car or a pickup truck. We have those too. You would submit them to me. We always focus group them first to make sure that they meet all of our criteria. We do virtual focus groups once a week, sometimes twice a week. And it's Greg and David and myself and Mr. Keenan and some of the office, and we review it all. Melinda Young is a new fellow with us. And so I've been working with her. Cool. And once we focus group it, if we accept it, then, we come and we talk to you about the training that you can get, the beach, because the beach is the place that everything starts. It is Mr. Keenan basically comes out with everything new happens at the beach. The good news is we're going to go back to, live workshops in 2022. So I'll actually get to see some people, I haven't seen in a long time, actually face to face. So that's the process. You can also just give me a call, and we can talk about it on the phone. But even if you don't, the things that we've been talking about are the things that need to be implemented in your practice. Early research. Our way is the harder way. It's more work, but the rewards are a lot bigger at the end.
What if we've already filed or we're in litigation? Is it too late to submit something for consideration?
Well, it depends where you're at. I mean, if you've finished all the depositions, if you have trial, 2 months from now, you are probably too late. Mr. Keenan does, we don't want to accept something where we can't provide you value, where we can't really have the impact on the outcome that we want to have. We could take cases all day long, but we have a specific notion that we want to make you better lawyers, that we want to make the cases better cases, that we want to show you things you haven't seen before. So if you've done so much that we don't have the room to do that, then yes, it would be too late.
But somewhere in the middle, I remember, I think we had filed. Yeah. And when we became referring attorneys, but I think we were really early on in discovery, and I'm not sure that we had taken any depositions. So it kind of, just for the audience, if you're wondering when you can reach out and try your hand at becoming a referring attorney, it can be a little after filing suit, even if you haven't done the early work. And let me tell you, we had to do some backpedaling in our case, right, Mindy?
Yeah. And if you remember, you hadn't taken the depots yet because we role played at the Santa Rosa Beach office with you and Young G and me, and we role played those depots before you went and took them.
Yep. That was the first time we learned about hit lists. That was the first time we learned about how to get the topics, and how to formulate the questions. I mean, it's a really wonderful experience, everyone. I highly encourage you to do it, and keep submitting cases too, right? Mindy, tell us a story about how many cases you submitted to Don before getting to work with him.
I think that we submitted 5 before he said okay to the first one. And then I can tell you that it changed the way that I practice law. I mean, there's no other way to say it. Being able to watch and hear how Mr. Keenan thinks things through is is really an amazing process that forever changes how you see your own cases.
It helps me screen cases differently too, I feel. Like right when they come in, I'm looking for different things because of the things that you guys found out were issues in cases we sent over to focus group.
Well, yeah. And the thing of it is, what I hear a lot of is I can't run my practice and do everything you want done. Well, Mr. Keenan's attitude is you shouldn't have so many cases that you can't do these things because that's what the cases deserve. This is the work they deserve. But you benefit because you have me that you work with, you have Mr. Keenan that you work with, you have all the things that go into play, and some pretty amazing stuff comes out.
Yeah, it's a wonderful resource. I mean, even though we're not referring attorneys anymore, we're still continuing to submit cases so that, we hopefully will be again, but you guys are there, when you have a moment, you'll answer questions still. And we appreciate that. And to have that resource, everyone who's listening is fantastic. So I encourage everybody to get super involved. Well, Mindy, anything else you wanted to share with us this afternoon?
Just that what you will find is that, Mr. Keenan in both these podcasts at KTI, on his blogs really shares with you the information that if you study it will make you a better lawyer. If you are not happy with where you are at, you can change it. I promise you that because I did. So that's probably it.
Thank you, Mindy. We'll put Mindy's contact information in the description below so that you can reach out to her directly with questions about tractor trailer cases, the EDGE system, and possibly becoming a referring attorney with the Keenan Law Firm. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked today's episode, please click that thumbs up and don't forget to subscribe and sign up for alerts so you don't miss the next one. Next week, we will be hearing from Neil Anthony as part of our Superstar series. Neil achieved a stellar result in a recent case and will be sharing about how the EDGE method helped him get justice for his client. I can't wait to hear what worked for him and get some inspiration for my own cases along with all of you. Have a wonderful weekend, and I'll see you next time.